Hello, and thank you for joining our third annual Day with DISA. Before the session gets started, let's go over a few things. A copy of the presentation will be available to download once the session has ended under the Materials section. If you have questions about the information in this session, enter them in the Q&A section below, and the speaker will answer them once the session has ended. If we don't get to your question, we'll reach out to you at the end of the conference. If you have questions about the topics or trends that are mentioned throughout Day with DISA and how they pertain to your company, and you'd like to reach out to one of our team members directly, hit the chat icon at the bottom of daywithdisa.com and you'll be connected directly with one of our team members. Thank you for attending live. Each of our live attendees is eligible for our prize drawing at the end of the conference. And each session that you attend live increases your chances of winning either a Nintendo bundle or a brand new iPhone 12. Finally, I'd like to take this time to thank all of our sponsors for their participation in Day with DISA. Specifically, I'd like to call out FCRA, our title sponsor for 3 years running. We'd like to thank our platinum sponsors, OraSure, Quest Diagnostics, Samba Safety, and Psychomedics. All of our sponsors' support is greatly appreciated. With that, let's get started. Enjoy your session.
Hi, thank you so much for joining us today for our session on FCRA 101. Today, our host is Morgan Reynolds. He's been with DISA and formerly AWSI for more than 10 years, and he is the Director of Background Screening Compliance. Morgan?
Thanks, Thomas. It's great to be here to talk to everyone, and I really am passionate about background screening and FCRA compliance, so this is a great opportunity for me to pass along some of the things that I've learned over the years. Background screening continues to be one of the most litigious areas of employment screening, and compliance is extremely important. So again, this is an FCRA 101 session, so it's going to be very basic in the material we've covered, but I hope to pass along some information that I've learned through the years that provide some context. Okay, so today we're going to talk about what is the Fair Credit Reporting Act, which is one of the things I get asked about a lot. Like, what is the Fair Credit Reporting Act? Why does it matter in background screening? It's got credit in the name, like, isn't that the credit bureaus and all that? So we're going to talk about that. Then we're going to go through the requirements prior to ordering a background report, and that's an end user requirement, and I'll get into the industry jargon, like end user is the employer and things like that. But that's going to be the second part that we're going to cover. So what do you have to do before you order a background report? And then the third part, we're going to go through when you get that background report and it has things that may cause you to make a hiring decision. What do you do? What's the process? So we'll go through those three things, and then we'll take some Q&A at the end. So if you do have questions, you can just put them in the chat, and Thomas will ask at the end. So what is the Fair Credit Reporting Act? So the Fair Credit Reporting Act, and I'll refer to it as the FCRA throughout, that's the short, and then you'll hear some people call it FCRA. FCRA is a federal law that helps to ensure the accuracy, fairness, and privacy of the information in consumer files. It was passed in 1970, and the FCRA helps consumers by regulating how information in the consumer report can be used and accessed. So most commonly, people are aware of the FCRA because of the credit bureaus that I mentioned earlier. There's Equifax, Experian, TransUnion, and so that's where it started. But as part of a consumer report, which is a background report, we also fall under the FCRA. So the FCRA has certain permissible purposes and requirements and things like that. So we do our background reports and everything falls under the Fair Credit Reporting Act, which causes a lot of confusion. for people. And that's why we're constantly explaining that, you know, we are what's called a consumer reporting agency under 603F of the Fair Credit Reporting Act, and I have the site there. Background reports are consumer reports under 603D. And the users of consumer reports are called the end users and must have a permissible purpose under 604. So consumer reports, the background reports, criminal history, things of that nature, that's most commonly what's ordered through DISA. Employers, people making a hiring decision based on that, those are the end users. And then the permissible purpose would be things not just that DISA provides, but things like employment, tenant screening, due diligence investigations, site access, all of those fall under permissible purposes under the FCRA under 604. So that's a little bit of an overview of what is the Fair Credit Reporting Act. The Fair Credit Reporting Act has a lot of requirements on our operations, but this session is focused on end user and FCRA 101. But just to give you a slight overview, there's things about how we do our operational aspects and accuracy and disputes. And so the FCRA is a guide for the back end of how DISA provides the services. So now I'm going to move into background ordering requirements. And so basically, you have a candidate, you want to hire them, and you want to run a background check on them before you hire them. So what do you do? So the first step is you are going to make a disclosure to them about consumer reports. So under the FCRA, whenever an employer seeks to obtain a consumer report, what I call the background check, the FCRA mandates that you must make a clear and conspicuous disclosure that a consumer report may be obtained for employment purposes, and further require that the disclosure must be in a document that consists solely of the disclosure. So what does that mean? Like that was hard for me to read. It's hard, you know, it's very unclear, even though it's saying to be clear. So the way I explain it is the disclosure, you're telling them what you're going to do. You're disclosing to them that you're going to do a background report on them, and it's going to cover criminal records. It's going to cover motor vehicle reports. It's going to cover employment verifications. You're going to verify their education. So it's the disclosure. You're telling them what you're going to do, and then it needs to be clear and conspicuous. So you don't hide the disclosure at the bottom of the application, right? So most employers will have their applicants fill out an employment application. And what people used to try to do is just throw in the little disclosure at the bottom. So they're filling out the application, then they get the disclosure, and that's where they disclose that they're going to do background, and then they do an authorization, which we'll talk about next. No, it needs to be clear and conspicuous disclosure telling them that you're going to run a background report for employment purposes, so you're considering hiring them, and then the document should consist of solely the disclosure. So that's the key, right? I talked in the beginning about how background screening is highly litigious, right? So here's the first example of that. So the applicant disclosure, right? So Gilbert v. California check cashing stores. So the Ninth Circuit in California, or in the federal courts, excuse me, held that the statutory language prohibited employers from including any superfluous information in the disclosure document. So in the Ninth Circuit, at least, and likely everywhere, employers cannot include disclosures required by other state laws in the same document that contains the disclosures required by the FCRA. The court also indicated that any language in the disclosure document that could confuse a reasonable person about his or her rights under the FCRA, likely will violate the law's clear and conspicuous requirement. Okay, so there's a lot to unpack here. The clear and conspicuous requirement at the end, let's talk about that. So if you are including other information in the disclosure, the court's basically saying that that's not clear and conspicuous. So if you have a state mandated disclosure or something of that nature that's not related to the FCRA, that's creating more information in the disclosure, which could confuse the applicant and therefore nullify meeting the disclosure requirement. So we have sample forms, DISA, and if you don't have, or if you haven't reviewed your disclosures and authorizations in some time or ever, then reach out to customer service. We can get you our sample forms, which you could adopt as your own, but they are 5 or 6 pages, but it's very simple, right? It keeps the disclosure on one page and then the authorization and then the state law requirements. And so it makes it easier for you, even though it's more paper or electronic forms that they have to click through. You really want to keep the disclosure separate from any other aspect of the pre-employment process. So you don't want the disclosure attached to the application in any way. It should be a standalone document. The language should be clear in the disclosure. So I would recommend going through either your HR or outside counsel and having them review your forms. You know, DISA is a service provider. We don't provide legal advice. We do have the sample forms that you can adopt as your own, but it's always the best practice to have your forms reviewed internally and through your outside counsel. So disclosures has been a highly litigious area of background screening recently. And that's just disclosing to them what you're going to do as part of the pre-employment process. So here's some common disclosure mistakes. Don't include language that claims to release you from liability for conducting, obtaining, and using the background screen report. So the disclaimer or release that will create superfluous information on the disclosure, which would nullify the clear and conspicuous requirement. So that's why you don't want to do that. Don't include a certification by the prospective employee that all information in his or her application is accurate. So people always want to hire or to make hiring decisions based upon whether or not they disclose something on the application, right? They'll have the area in their application and then they want you to certify that everything in the application is accurate. And then if it comes up on the background report, it's like, I gotcha. Well, there's a whole another session that we could do on ban the box laws and things like that. You probably don't want to ask about their criminal history on the initial employment application because of ban the box laws. We're not going to have time to get into ban the box laws today, but that could be a future session and certainly something that you should review with your HR or outside counsel, your employment application. Delete any wording that purports to require the prospective employee to acknowledge that your hiring decisions are based on legitimate, non-discriminatory reasons. Again, this is just language that's not part of the disclosure, so it could confuse the reasonable person. And then get rid of overly broad authorizations that permit the release of information that the FCRA doesn't allow to be included on a background screening report. So there's certain limits on the background screen report. You know, non-convictions can only be included for 7 years. If it's a credit report, you can only include, I think, bankruptcies for 10 years, things like that. And I've seen disclosures where they try to say, no, I'm okay with everything, and that you can't override the FCRA in that manner. All right, so we've talked a lot about disclosures, and so it's really a two-step process. It's the disclosure, and then the candidate provides authorization. Fortunately, the authorization is much simpler. It's just an employer must obtain the written authorization of the candidate prior to requesting a consumer report and/or an investigative consumer report. So the FCRA simply says the consumer authorization must be in writing. So electronic signatures are okay, as long as you have consent to receive it from them electronically. But it's really just a clear authorization that they sign, and that makes certain that they're authorizing you to do everything that's in the disclosure. So the candidate authorization walks hand in hand with the disclosure. So those are the first two steps in the candidate in ordering a background report. Got to disclose to them, and then you get their written authorization. And sometimes I get asked, well, do we have to do it prior to ordering the background report? Like, can we just get their authorization, but we got to get them on the job site? Yes, it's always got to be before you go into DISA Works and you place the order, or whatever system you're ordering through your ATS, if you're integrated that way. If you're submitting a background report, you must have their authorization prior to doing so. Okay, the next step in the before you order a background report is going to be the end user certification. And this is one that I'm getting asked a lot more questions about, why DISA does the things that we do as part of the end user certification. But it's in the FCRA 604B, the end user, which is everyone on this session, the employers, the person making the hire of the candidate, the end user must certify compliance to the Consumer Reporting Agency, DISA, from which they are procuring the consumer report that they notified the applicant or employee and got their permission to get a consumer report. So that's what we just talked about, right? The disclosure and then the authorization. So you have to certify to us that you have that already before you're placing the order, that you've complied with all the FCRA requirements, and that you will not discriminate against the applicant or employee or otherwise misuse the information as provided by any applicable federal or state EEO regulations. So those are what is required of the end user, and we meet these certification requirements through the DISA Works platform or our DISA 360 platform, or if you're integrated through an ATS, we have our certification queue. So all we really need is for you, the end user, to certify to us that you've met these requirements, the disclosure and authorization, that you'll do adverse action, which we're going to talk about in a few minutes, if you do make a hiring decision in whole or in part based on the consumer report, and that you're not going to discriminate against the person or violate any EEO laws. So we have this certification built into the platforms, and then we have what we call the certification queue if you're integrated through an ATS, where you have to check a box and certify. And that's really all you have to do. But frequently we're asked, well, can we just certify like annually or once a month or things like that? And so the way that the trends are in the industry, we need that certification with each order. So DISA is required to get the end user certification that you're going to follow these 3 steps with each order. That's why we built it into the platform. That's why we have the certification queue if you're integrated with an ATS, applicant tracking system. And that's why we have the system set up the way we do, is to ensure that we're following the Fair Credit Reporting Act. Okay, so we've talked about what is the Fair Credit Reporting Act, and then we talked about what to do prior to ordering a background check. Now you've ordered the background check, and it's gone through, you ordered criminal records, you ordered a motor vehicle report, you ordered employment verifications, education verifications, and it comes back and the person has something on their background which you may potentially not hire them. And the reason I say potentially is what we're going to talk about now, because when you get the background report back, the FCRA requires a two-step adverse action process. So step one is pre-adverse action. So pre-adverse action means that you're going to notify the applicant or employee that information in the consumer report may potentially impact the hiring decision. You're going to provide the consumer a copy of the report and a summary of their rights under the FCRA. DISA has a sample pre-adverse action letter available, and we also have a way to provide that to the applicant on your behalf. If you don't have that set up and you're a corporate client, not on the consortium side, contact customer service to have that service added. So basically the pre-adverse action gives the applicant the opportunity to review the report and tell you if it is correct. So they're going to get a copy of the report, and so it's going to have the safety net search, the county criminal search, the statewide search that you ordered, the federal criminal search, education, employment, motor vehicle report. Now, there's going to be information on there that's causing you to potentially not hire them. So they may have had an employment verification where the previous employer was contacted, they claimed to be the manager, and they said, no, that was a laborer, they weren't a manager, and that was relevant to your hiring decision. Well, this is their opportunity to review the report and dispute the accuracy or provide you more context with that report. So they could say, no, I was a manager of 3 people, and that was my duties. My title was what they had in the payroll system or something. But it's their opportunity to be put on notice that you're going to potentially use this information to make a hiring decision. Okay. So we've talked about the pre-adverse action, right? So we sent them a copy of the report. We sent them the pre-adverse action letter, a summary of their rights under the FCRA, and they now have had the opportunity to review the report, dispute its accuracy, but the FCRA requires one more aspect. There's a waiting period requirement. So it just says a reasonable waiting period. It's not explicitly prescribed by the FCRA. Courts and the FTC suggest 5 days is reasonable. So basically this waiting period is giving them time to digest the information they get and contact the consumer reporting agency to dispute the accuracy, review the report, and then talk to you, provide more context to the report. But this is a frustrating part of the FCRA that I find for clients, is they don't want to wait the 5 days and they just want to send the adverse action. They want to make the decision. But this is what the regulations require, is a reasonable waiting period. And so for most places, 5 days. I will advise you to make sure that there's no local laws on the books. I would talk to your HR professional to see if there's any additional time required. I know Philadelphia requires 10 business days waiting period, and there could be a couple others. Again, we're not providing legal advice as part of this session, but I would reach out to your HR professional or check local laws, because there could be others on the books for this waiting period. Okay, so adverse action notification. So we've sent the pre-adverse action. We've waited the 5 days. Now, we're going to again send another letter to the consumer that a state, and as part of the adverse action, we need these statements to be in it, right? A statement that the action being taken is based in whole or in part on a consumer report received from a consumer reporting agency like DISA. Contact information for the CRA. A statement that the consumer reporting agency did not make the decision to take adverse action and is unable to provide the consumer with the specific reasons why the adverse action was taken. So these are the FCRA requirements for that adverse action. In DISA sample letters, we have the adverse action letter, and then we again send a copy of the report and a summary of the rights, and then these required statements. So again, if you don't have the proper letters, reach out to client services. We can get you sample forms, or we can get you set up to automatically send these letters on your behalf. So let me talk a little bit about each of these. So many times I'm asked, well, I was a little unsure of this applicant, and it's not the whole consumer report that's causing us not to hire this person. Do we still need to go through this adverse action notification? If any aspect of it impacts the hiring decision, you must send the pre-adverse and adverse action, right? So that's why it says in whole or in part, on whole or in part. And so if it's 95% one thing and 5% the consumer report, you still need to send the pre-adverse action. The contact information for the CRA. So that is required because it gives the consumer the opportunity to reach out to DISA to get a copy of their report, again, their file, or dispute the accuracy and go through the dispute process. And then in it, a statement that the consumer reporting agency did not make the decision to take adverse action and is unable to provide the consumer with the specific reasons why the adverse action was taken. So this is straight from the FCRA, but DISA gets calls all the time from consumers who receive their adverse action letter and they want to state their case to us. Why? They want to explain that they had something and the court told them it was going to go away if they did X, Y, and Z, and the conviction's not them, and everything. And we have to tell them, we're not making the hiring decision. We don't know necessarily why the employer is making the hiring decision. We're reporting the public record, right? We're reporting the public record at the criminal courts, or we're reporting, a motor vehicle report, employment verifications, things of that nature. So a lot of times the consumers get confused on the reasons why, and the adverse action directs them to the hiring manager or HR for direction on that part. Okay, additional requirements as part of the adverse action letter. So a notice that the consumer may receive a free copy of the report after proper identification is made. So as I talked about before, the DISA contact information is within the adverse action notice, so they can reach out and get an additional copy of the report. Now, they should have gotten copies along the way, and they did, but if they want another copy, they can reach out and get that. A statement that the CRA is not required to remove accurate derogatory information from the file of the consumer unless the information is outdated under Section 605 or cannot be verified. So we frequently get people reaching out asking to have information removed, but we actually cannot remove any of the information that's reported unless it's, because we're reporting public record, unless it's unable to be verified at the source. And then a statement that the consumer may have additional rights under state law and that the consumer may wish to contact the state or local consumer protection agency or a state attorney general to learn of those rights. So it's just notifying them again of their rights. And as I talked about at the beginning, the FCRA, the tenets of the FCRA are about notifying the consumers of their rights and ensuring that they have a fair and accurate avenues with regard to their public information. Okay, so just to review what we've talked about. So we've covered what is the Fair Credit Reporting Act and how does it define the background check process. So even though most people would hear Fair Credit Reporting Act and think of the credit bureaus and credit reports, employment background checks are covered under the Fair Credit Reporting Act, and that guides many of DISA's processes operationally. Okay, we also talked about the disclosure and authorization process, how to complete it. I just want to reiterate and go back into the disclosure and authorization. If you haven't reviewed your disclosure and authorization forms recently, like in the last year, it's worth your while to go through and have them reviewed by outside counsel. We have our sample forms that you can adopt as your own, but you also want to do your own review of those forms. This is the hottest topic in of litigation in background screening. And background screening FCRA litigation is a hot area in general. So the disclosure and authorization form process is where plaintiffs' attorneys are really going after. And, you know, we would see a lot of employers combine the disclosure and the authorization onto one form. And that is something that when a plaintiff's attorney sees that, they're definitely going after. So just to reiterate, if you haven't reviewed them recently, if you haven't had counsel review them, I highly recommend going through that process. All right, so we talked about that. We talked about the end user certification requirements and what you must certify to DISA as part of the background screen. 604B, we require certification on DISA Works, or if you're through an applicant tracking system, there's a certification queue. On DISA 360, there's a certification checkbox that meets these requirements. I'm frequently getting asked about doing it weekly or monthly or annually, doing the end user certification, but we must have it with each order. That's just the industry trend and the best practice based on litigation that we've seen and we've monitored, is that we have to get that end user certification. I know it's an onerous process that employers don't love, but that's the requirements and that's where we are. Okay, and then we talked about when you get that background report back and making a hiring decision in whole or in part based on the background report, how to complete the adverse action process. So we went through pre-adverse action, the 5-day waiting period, and then the adverse action notification and all the required information that must be in that adverse action notification. So they're going to get a copy of their report, a summary of their rights, and then the letters, and that will complete the hiring decision. All right, here's my contact info. Again, my name is Morgan Reynolds. I'm the Director of Backgrounds Compliance. And so now let's move on to a little bit of Q&A. I think we've received several questions as we've gone through.
Yeah, that was great, Morgan. Thank you so much for your time and sharing your expertise with the attendees today. Before a little bit of housekeeping before we dive into the question and answer. If you'd like a copy of the presentation, we made a PDF available in the materials section at the bottom right. And if you want to ask a question, there's a Q&A section down there. Just ask your question. If we aren't able to get to it now, we'll reach out to everyone that asks a question after the event as well. So please do ask those questions. I know we've got a number of them in the queue, but we'll reach back out to everyone after the conference. Morgan, if an applicant has records which disqualify them, can they skip the pre-adverse action and go straight to the adverse action?
Okay, so this is a very common question. Okay, Thomas, you hit on a person who submitted this, asked a great question, because I get this one all the time. And I understand, like you get the background report, and let's say they have a criminal record, which is job related, and you're clearly not going to hire them as long as it's accurate. So you just want to move on from that applicant. You just want to send them the adverse and say, no, thank you. You cannot do that, okay? You absolutely have to send them the pre-adverse. The FCRA is a consumer protection statute, right? And so it's built in to protect the consumers of their rights. So they have to get a copy of the report. They get a chance to review that report, dispute the accuracy, ask additional questions, provide additional context to you as part of that. And then there's the mandated reasonable waiting period, which, as I talked about just before this, was 5 days has been considered reasonable. So clients are waiting at least 5 days, and sometimes they wait a couple extra days. But that's the minimum, is the 5 business days. So again, FCRA, Consumer Protection Statute, you must send the pre-adverse. Even if it's clearly job related and you're not going to move forward with that candidate, they must have the opportunity to dispute the accuracy of their report. So just keep that in mind. But great question, thank you.
Another question kind of in that same vein is regarding the 5 days, is that just 5 calendar days? Is that 5 business days? And do you need to account for time in the mail?
Okay, so that's a very specific question, and also a good question. So the 5 business days is reasonable, right? 5 business days, that's the reasonable interpretation. But we have clients who, to account for that mail time, they give them a couple extra days before they make the hiring decision. We have clients who send the pre-adverse via email to the candidate to make sure they get it immediately, to give them the entire 5 days to dispute the accuracy, provide additional information. And then the other thing is, some will send an overnight package, via FedEx or whatever, UPS, to the candidate to make sure they get everything in paper form. But the pre-adverse, for many clients, they do treat it as a pre-adverse, right? They're not certain what they're going to do. They're using this as an opportunity to see how the candidate responds. Like, they may have records and they're not sure. And so if the candidate calls and provides additional information and they actually want to engage with that consumer on their records and hear the context that they provide, or if they want to dispute or make sure that they're having their opportunity to use their rights under the FCRA. So very good question, but the 5 business days it's 5 business days, and it's used by clients in many different ways.
Thank you, Morgan. We conduct employment verifications as part of our background checks. If there's information that is not verified in the report, can we use that? Do we need to use the adverse action process to deny employment?
Okay, so I talked a lot about criminal records, and so this is a perfect question, because I probably went over the pre-adverse action a little bit too much related to criminal records, but this is a good opportunity to review that and just go through that. It's anything on the consumer report. If it's a motor vehicle report, if it's an education verification, if it's an employment verification, it's not just related to criminal records. It's anything on the report. So if it was an education verification that they asked about, or employment, I don't remember, Thomas, but either way. Employment verification. So they said they were the manager at a place, and we call and verify, and they say, no, that person never worked here. So it comes back as a not verified employment. Absolutely. You go through the pre-adverse action and provide them a copy of the report. In that same vein, if they have a motor vehicle report and they have 5 or 6 tickets, and it's something that is a driving position, and you're going to use that motor vehicle report. You send them a copy of the entire report, not just the employment verification or the MVR, motor vehicle report, employment verification, whatever. You send them a copy of the entire report.
Great. Another question in that same vein is, when sending the pre-adverse action, do you need to specify what the disqualifying factor is, or do you just keep it broad?
So we're talking basics here. So if we're talking and getting into the details, and that's why constantly I'm telling you to review with your outside counsel, because there are state law distinctions. But in California, it is required that you specify what on the report is causing the potential hiring decision, right? So as pre-adverse, you tell them, you know, this record or this motor vehicle report, the number of violations, whatever, you have to specify that in the pre-adverse action. Under the FCRA, it's not required. I think the best practice is to include that information as part of the pre-adverse and notify the consumer. Again, it doesn't hurt to tell them what is on there that's causing this potential decision, right? It gives them more information. They can look at it, and then they can formulate a response to you on the context, or provide you additional information and go through the dispute process, or just know what is on the report. So it's required in California, and there may be local ordinances in small cities, but I know for a fact in California, and then FCRA does not require that.
Thanks, Morgan. So what does DISA do for me regarding FCRA requirements?
Okay. What does DISA do for you? Okay, that's a great question, because if you are a consortium client, you're sending employees to job sites to do work and going onto owner sites, and let's say they fail the access requirements, then as part of the site access, DISA automatically sends them a pre-adverse action letter, and then gives them the waiting period, and then sends them the adverse action if there's no additional information or that. So that's for site access via the consortium. On the corporate side, if it's an employment background, then that's a custom setting. So if you want that service and you want the pre-adverse action to go, or to be set up in our system, then please contact client services. They can go through and take care of that. And then as part of FCRA, as I talked about earlier, we have sample forms. We have a welcome letter, which everyone received when they were set up, but if you need it again, they can get you all that information, which has all the state mandated forms, disclosure and authorization forms, a bunch of different compliance pieces. And it's good to review that, even if you've already received it, go through and see it, because states have specific mandated forms that you must receive.
So Morgan, another question. I have an employee who's been with me for years, but now I need to get him on site with a DISA mandated owner, and I have to do a background check. Do FCRA rules apply?
Yeah. So that's a good question. So we've talked mostly about employment purposes, and if you recall earlier on, I talked about permissible purposes, right? So the FCRA has a bunch of permissible purposes. So employment is one, and then the security site access would fall under a different permissible purpose. So yes, that would be a different permissible purpose, but still would fall under the FCRA. So it would require the pre-adverse and adverse. The other thing is you don't want to use the same background. So if it's one permissible purpose, you want to use that for site access, you should be doing employment background checks separately from your site access. So that's something to consider and get set up if you're crossing over, because that's not compliant to use them for two different permissible purposes.
Do adverse action apply when running background checks on 1099 contractors?
So you're running a background check, and even though it's not an employee, it's going to fall under the employment purposes under the FCRA, and that's 1099s, that's volunteers, which I get asked about a lot, is we like a volunteer organization. So they have volunteers who are going to come in and, you know, coach baseball for a youth group. And so they're running background checks, which is, you know, if you're part of volunteer organizations and they didn't run a background check on you, you may want to notify the board to be running background checks on the volunteers. But anyway, under the volunteers and 1099s, it's considered employment purposes for the permissible purpose. So yes, it falls under the FCRA, and yes, you need to do the pre-adverse.
So Morgan, what if a candidate does not consent to a background check?
Okay, so if they don't provide their written authorization, they don't authorize you to do it, then you don't do a background check, okay? So we talked about that earlier in the presentation, right? So you give them disclosure and then you get their written authorization. If they don't do it, don't order it. Please do not order it, okay? And then if they don't participate in your hiring process, your pre-employment process, then you can make that part of their hiring decision, you know, not move forward with the candidate. You're under no obligation to hire them if they won't participate in your hiring process, but you cannot run them unless they authorize you to run them. So that's a great question, and it's something that frustrates end users frequently when the candidates are like, no, I don't want you to do a background check. And they're like, well, they really wanted that candidate. Well, you know, that's their prerogative not to consent to being part of your pre-employment process. And then you can use that information to move forward as you choose. And it wouldn't fall under the FCRA if they don't participate, if they won't sign it. There's nothing to send, there's no pre-adverse action, they're just opting out of that process.
Gotcha. Well, hey, Morgan, we're out of time here. I want to say thank you so very much for, again, lending your time and experience with the audience.
Thank you, Thomas, and I hope this information was valuable for everyone. And again, my contact information was included, and submit any additional questions and we'll get you a response. Thanks.